the Chamber has scheduled this hearing in order to provide the decision on the requête de la défense de Laurent Gbagbo afin qu'un jugement d'acquittement portant sur toutes les charges soit prononcé en faveur de Laurent Gbagbo et que sa mise en liberté immédiate soit ordonnée. And on the Bles Goude defense case, to Bles Goude defense, no case to answer motion. So as the decision on the request for provisional release following the hearing convened by the Chamber on continued detention of the accused. The majority of Trial Chamber 1, Judge Herrera Cabucha dissenting, notes as follows. First, it is a matter of public record that in the period under scrutiny by the Chamber, i.e. November 2010, April 2011, Ivory Coast was torn by a violent political conflict in the context of the presidential elections in Abidjan and in other parts of the country. On June 23, 2011, the prosecutor of the International Criminal Court requested authorization to investigate whether crimes within the jurisdiction of the court were committed in the context of this conflict. And on 3 October 2011, Pretrial Chamber 1 of the International Criminal Court authorized such investigations. Following requests by the Office of the Prosecutor of 25 October 2011 for Mr. Gbagbo and 12 December 2011 for Mr. Bles Goude, Pretrial Chamber 1 issued warrants of arrest against the accused on 23 November and 21 December 2011, respectively. Mr. Laurent Gbagbo was surrendered to the International Criminal Court on 30 November 2011, and Mr. Charles Bles Goude on 22nd March 2014. The charges against the two accused were confirmed by Pretrial Chamber 1 of the ICC for Laurent Gbagbo on 12 June 2014, and for Charles Bles Goude on 11 December 2014. Following the joinder of the two cases and the period for its preparation, the trial commenced on 26 January 2016 before this Trial Chamber 1. The Chamber set for 231 hearing days, receiving evidence from 82 prosecution witnesses in court and through video link. Thousands of documents were submitted into evidence. Hundreds of submissions, motions, requests by the parties and participants, and decisions by the Chamber were filed. Following the conclusion of the presentation of evidence by the prosecutor, the Chamber was seized of requests for the acquittal and immediate release of both accused. Pending the resolution of these requests, the Chamber convened a hearing to discuss the continued detention of the accused on 13 December 2018. During this hearing, both accused asked to be relieved with or without conditions. The Chamber, having thoroughly analyzed the evidence and taken into consideration all legal and factual arguments submitted, both orally and in writing by the parties and participants, finds by majority that there is no need for the defense to submit further evidence, as the prosecutor has not satisfied the burden of proof in relation to several core constitutive elements of the crimes as charged. In particular, the majority finds that the prosecutor has failed to demonstrate that there was a common plan to keep Mr. Gbagbo in power, which included the commission of crimes against civilians, has failed to demonstrate the existence of the alleged policy to attack the civilian population on the basis of the alleged pattern of violence and other circumstantial evidence cited in support, has failed to demonstrate that the crimes as alleged in the charges were committed pursuant to or in furtherance of a state or organizational policy to attack the civilian population, has failed to demonstrate that public speeches for Mr. Gbagbo or Mr. Bles Goude, by Mr. Gbagbo or Mr. Bles Goude, constituted ordering, soliciting, or inducing the alleged crimes, or that either of the accused otherwise knowingly or intentionally contributed to the commission of such crimes. The Chamber will provide its fully and detailed reasoned decision as soon as possible. The Chamber recognizes that it would have been preferable to issue the full decision at this time. However, Rule 144.2 of the Rules of Procedure and Evidence states that the Chamber must provide copies of its full decision, and I quote, as soon as possible after pronouncing its decision in a public hearing, and there is no specific time limit in this regard. The majority is of the view that the need to provide the full reasoning at the same time of the decision is outweighed by the Chamber's obligation to interpret and apply the Rome Statute in a manner consistent with internationally recognized human rights as required by Article 21(3) of the statute. Indeed, an overly restrictive application of Rule 144.2 would require the Chamber to delay the pronouncement of the decision, pending completion of a full and reasoned written statement of its findings on the evidence and conclusions. But given the volume of evidence and the level of detail of the submissions of the parties and participants, the majority, having already arrived at its decision upon the assessment of the evidence, cannot justify maintaining the accused in detention during the period necessary to fully articulate its reasoning in writing. The deadline for appealing the present decision will start running at the moment the parties are notified of the full reasons for it. The prosecutor may seize the Chamber of a request under Article 81(3)(c) (i) as of today. For all these reasons, the Chamber, by majority, hereby decides that the prosecutor has failed to satisfy the burden of proof to the requisite standard as foreseen in Article 66 of the Rome Statute, grants the defense motions for acquittal from all charges against Mr. Laurent Gbagbo and Mr. Bles Goude, orders the immediate release of both accused pursuant to Article 81(3). No! Come on! Please. Can you... Please, I appeal to the public. Please sit down. Otherwise, I have to evacuate. Please sit down and please behave. Okay. Ordered the immediate release of both accused pursuant to Article 81(3)(c) of the statute, subject to any request by the prosecutor under subparagraph I of this article. Decides that the deadlines for appealing this decision run from the issuance of the full reasoned decision. Decides that the pending request for provisional release have hereby become moot. Judge Herrera Kabucha has issued a dissenting opinion in writing, which will be filed this morning. This concludes the Chamber's oral decision. And I revert now to the Office of the Prosecutor to ask if the Office of the Prosecutor wishes to make a request under Article 81(3)(c)(i) of the statute.
Your Honors, because you are, well, first of all, thank you for allowing me the floor. We take note of your summary, oral summary provided this morning. Now the point is the following. In order for us to be able to act responsibly and make meaningful submissions under 81(3)(c)(i), we need to have the full substance of your decision. And we don't have that now. As the Chamber knows, it's under exceptional circumstances because we were expecting to have a full written decision, obviously notified later today following your announcement this morning. And we would have requested, and our intention was to request 48 hours in order to make those meaningful and responsible assessments of your decision, which we cannot make at this stage. It was also our intention to argue that under the said provision, while it states that continued detention can be ordered on exceptional circumstances, we were going to argue that obviously if you have the power to detain, you have the power to release under conditions. And that's what we were going to recommend this morning. But right now I cannot make these submissions because we don't have the judgment. Now, what I would recommend at this stage is a short recess of 30 minutes in order for us to regroup legally to assess our procedural avenues in light of the fact that this decision is not available at this stage. And if you allow me just 1 second. I think, Your Honors, it would be wise Also, we understand that there's a dissenting opinion, which will be made available later today. Maybe.
Let me say, so I cut it short.
Yes.
I asked if you want to make a submission or request on Article 81, and the chamber was prepared if you say yes to postpone until tomorrow morning at 10 o'clock. Let me finish. You could say yes, and tomorrow then withdraw from it. So you have time until tomorrow, 10 o'clock, to think about it, and this could be a solution.
Thank you, Your Honor. We accept that we should reconvene tomorrow for 10 o'clock.
But
that's amenable at this stage.
Yes, but therefore my question is, do you want to avail yourself of the possibility to make a request under Article 81?
Yes, we want to avail ourselves of that possibility.
The second question is, are you ready to do it now?
No, in
Good.
light of the fact that the decision is not available.
Therefore, we adjourn the hearing to tomorrow morning. The order of release is suspended until tomorrow morning, until the decision on this. Thank you very much. The hearing is adjourned.
All rise. Vi will away.